Supreme Court invokes extraordinary powers under Article 142 to free Perarivalan. Hi, welcome to Candle IAS. On May 18, 2022, the Supreme Court invoked extraordinary powers under Article 142 to free Perarivalan, who was one of the convicts of the Rajiv Gandhi Assassination case which happened in 1991. In this lecture, we shall discuss in detail about these extraordinary powers of the Supreme Court, about Article 161, about Article 142, a brief background of the Perarivalan case and his role in the Rajiv Gandhi assassination case. Then we shall also discuss about why there was a delay by the governor to go ahead with the mercy petition, and then further the center or the union's stand, and we shall also discuss about the conclusion. What is Article 142? Under Article 142, the Supreme Court in its jurisdiction can pass any decree or order for doing complete justice in any cause or matter which is pending before it. Okay? Under Article 142, the Supreme Court in its jurisdiction can pass a decree or an order to give complete justice in any cause or matter before a case pending before it. So it is this powers under Article 142 which the Supreme Court utilized to free Perarivalan. It felt that there was a need to give complete justice to Perarivalan, who was a convict in this case, and so it utilized this extraordinary powers under Article 142, which we shall be discussing much in the further lecture. Article 161. Article 161 deals with the clemency powers of the governor. We know about the clemency powers of the president and the clemency powers of the governor as well. So Article 161 deals with the clemency powers or the pardoning powers of the governor. Article 161 states that the governor of a state shall have the power to grant pardon, reprieve, respite or remit, or to suspend, remit or commute the sentence of any person convicted of any offence against any law relating to a matter in which the executive power of the state extends. So, the pardoning powers are present with the president as well as with the governor. However, one important point which you need to keep in mind here is, it is only the president who can pardon a death sentence, whereas the governor cannot pardon a death sentence. Okay, pardoning powers of a death sentence lies exclusively with the president, whereas the governor can only pardon other sentences like life sentence and so on. Let's look into a brief timeline of Perarivalan's case. The Rajiv Gandhi assassination happened in 1991, and in 1991 CBI arrests Perarivalan, who was just 19 years old back then. Then in 1998 a TADA court, that is Terrorism and Disruptive Activities Prevention. So there was an act called as Terrorism and Disruptive Activities Prevention Act, which led to the formation of the TADA court, and it sentenced the 26th accused of this Rajiv Gandhi assassination death, including Perarivalan. Then finally in 2011, after a long gap, Santan, Murugan and Perarivalan were fixed, that is the day for their execution was fixed on September 9, 2011. So initially they were given the death sentence, but the date of execution for these three people was fixed on September 9, 2011. Meanwhile, they had approached the president for pardoning their death sentence, or they had filed a mercy petition. However, the mercy petition was pending on the president's table indefinitely, and the president failed to take any action on it. So what happened was, in 2014, the Supreme Court commuted the death sentence on the grounds of delay, in disposing their mercy pleas. So initially, their death execution was fixed for September 9, 2011. But after they filed for the mercy petition of the president, it was delayed for a very long time. And now, if they are going to execute them at a later point after 2 or 3 years, it will amount to double jeopardy. That is, already they have been given death sentence, and along with that, that is plus they have also served life sentence, or they have also served imprisonment for an additional 2 to 3 years, after which they have been given death sentence. Okay, so that is once they have been given death sentence, and in addition to that they have also served 2 to 3 years of imprisonment in jail. And now if they will be hanged, it will lead to, or it will amount to, double jeopardy. So what the Supreme Court does now is, because they cannot give, or they cannot punish a person twice for the same, for a single offense. Now what Supreme Court does is, it commutes the death sentence, because now in 2014, initially they were supposed to be executed in 2011. Now it's been 3 years after that, and now if they will be executed, it will amount to double jeopardy. So considering that, the Supreme Court commutes the death sentence on the grounds of delay. Keep this in mind. On the grounds of delay in disposing their mercy pleas, their death sentence was commuted to life sentence. Then immediately the very next day, that is on February 19, 2014, the Tamil Nadu cabinet decides to immediately release all the 7 convicts of the Rajiv Gandhi assassination case, including Santhan, Murugan, Perarivalan, Nalini, Robert, Jayakumar and Ravichandran. Next, in 2015, the Supreme Court says that the center will decide whether the convicts will be released or not. So earlier in 2014, Tamil Nadu cabinet decides that all the 7 convicts should be released. And then in 2015, the Supreme Court says it is the center which will decide whether the convicts will be released or not. And then in 2017, a former CBI officer makes a statement that the CBI omitted a part of Perarivalan's confession. So what was the role of Perarivalan in this Rajiv Gandhi assassination? As a 19-year-old, Perarivalan had bought 2 9-volt batteries which was used in making the bomb which was used in the assassination of Rajiv Gandhi. So when the CBI inquired Perarivalan, he gave a confession statement. He confessed that it was he who bought the 2 batteries, and he also made an important statement, or an important part, which said that he did not know for what purpose those batteries were used. However, the second part of the confession was omitted. So now in 2017, the CBI officer makes a statement about the omitted part of Perarivalan's confession. Okay, so Perarivalan said that yes, it was me who bought the batteries, but I do not know for what purpose it was being used, or for what purpose it was to be used. The second part of the confession of Perarivalan was omitted earlier, and now the CBI officer brings the omitted part to the knowledge of the court. So now in 2017 this happens, and then later in 2018 a 3-judge bench of the Supreme Court gives 3 months time to the union government to decide on his release, because he has already confessed that he did not know for what purpose those batteries were bought. However, it was earlier omitted, and now that the CBI officer has given that statement that he had already confessed about his lack of knowledge of the use of those batteries, now the Supreme Court constituted a 3-judge bench which says that the union government has to take a decision on Perarivalan's release within 3 months. Now, in 2018 itself, the centre rejects TN government's request to free all the 7 convicts of the Rajiv Gandhi assassination case. Then in 2018, in September, the government decides to recommend the governor to release all the convicts. So I already told you the governor has pardoning powers. The governor cannot pardon a death sentence, however, he can pardon the life sentences. So in 2018 September, TN government decides to recommend to the governor to pardon all the convicts of the Rajiv Gandhi assassination case, that is the 7 members. Next, there is an indefinite delay. So in 2018, the TN government recommends to the governor to pardon all the 7 convicts. However, the governor does not take any action on it. Neither does he pardon the convicts, nor does he take any action. Instead, he moves the mercy petition to the president. So later, after 3 years, now the Supreme Court on May 18, 2022 invokes its extraordinary powers under Article 142 to release Perarivalan. So what exactly is the role over here? Why does the governor send the mercy petition which was sent to him by the TN cabinet or the Tamil Nadu government? He follows it up or he sends that to the president. Is that actually constitutional? Let us discuss about that. On September 9, 2018, the Tamil Nadu government decides to recommend to the governor to release all the 7 convicts of the Rajiv Gandhi assassination case, including Perarivalan. Under Article 161, which deals with the clemency powers of the governor, the recommendations of the state government are binding on the governor. So, actually speaking, based on the recommendations of the state cabinet, the governor should have released all the convicts of this case. However, the governor chose to keep the recommendations pending indefinitely. He did not take any action on it and he kept the file pending on his table indefinitely. Then in May 18, 2022, the Supreme Court utilized the extraordinary powers under Article 142 to free Perarivalan. So what is the union government or the centre's stand in this case? The centre's argument was that it is the president and not the governor who had the power to grant pardon in a case which is considered as a murder case and it comes under section 302. So initially Perarivalan was given death sentence which was later commuted to life sentence, and even the terrorism charges were removed. So once the terrorism charges were removed, it became a murder case and it comes under Criminal Procedure Code. So according to this, the centre argued that the president has the exclusive rights to pardon a case under 302 of the IPC. However, this argument of the centre was dismissed by the Supreme Court, saying that if that is true, then Article 161 does not hold any value at all, isn't it? Article 161 deals with the clemency parts or the pardoning parts of the governor. If they say that it is only the president who has the exclusive powers to grant pardon in case of murder cases, then what about the pardoning powers of the governor under Article 161, isn't it? So this argument of the union government was completely dismissed by the Supreme Court. Next, initially the centre had assured the Supreme Court saying that the governor will decide the mercy petition of Perarivalan. But however, in November 2020, they completely changed their stance and they said that it is the president who can decide. So why did they do so? They said that based on this case, that is V. Sri Hariharan case. So according to this case and the judgment in this case, they said that since this case comes under the CRPC or the Criminal Procedure Code, because it is a criminal case, they said that the primacy, that is the primacy comes to the union and not to the state when they have to be tried under a law to which the executive power of the union extended to. So citing this case of V. Sri Hariharan, they said that the primary or the primacy to decide the mercy petition belongs to the union government and obviously it will be executed by the presidential order, right? So however, Perarivalan's lawyers utilized this same case to counter the argument, saying that you cannot equate the pardoning powers of the president and the governor to the powers of the state and the union which comes under the CRPC. Okay, so this case, that is the V. Sri Hariharan case, what is utilized by the union government to say that the primacy to the other primary power to decide a mercy petition lies with the union and not with the state. However, Perarivalan's lawyers utilized the same case and they said that the power to decide a mercy petition in a criminal case according to CRPC cannot be equated to the pardoning powers or the clemency powers of the president and the governor. Okay, so ultimately on May 18, 2020, Supreme Court invoked its extraordinary powers under Article 142 and finally freed Perarivalan after 31 years, because according to Article 142, it gives extraordinary powers to the Supreme Court to decide any case or order which it feels there has justice need to be done. So in this case, justice definitely needed to be done because he did not know the purpose for which the batteries which he bought was supposed to be used. So finally, he was freed. So now the next question is, what about the other 6 members who were also convicted in this case? So Perarivalan was one of them. What about the other 6 convicts who are still serving their life sentence in jail? Will they also be released by the Supreme Court by using the extraordinary powers under Article 142? We will have to just wait and watch. So as per UPSC examination point of view, what are the important articles and what is the important points which we need to remember is, first one is Article 142 and next is the pardoning powers of the president and the pardoning powers of the governor under Article 161, and we should also notice the difference between CRPC and the other articles. I hope you have understood this topic well and its relevance to the UPSC examination also. If you need me to make much more such informative videos, you can follow us on our social media, and if you have any more queries or doubts, you can comment in the comment section below. Until I meet you in the next lecture, take care, bye, and all the very best. Thank you.